The question is that the bill be now read a second time. The member for Victoria Park.
Thank you very much, Acting Speaker. I am pleased to rise today to speak to the Government's Bail Amendment Bill 2022, or perhaps relieved would be a better adjective. As the Attorney-General said when he read this bill for the second time in this place, almost 2 years ago, the McGowan government committed to examine the operation of the Bail Act 1982 and identify ways to better respond to bail applications for adults accused of sexual offences against children. We recognise the traumatic effect that the release on bail of alleged abusers can have on their victims, and we believe it is critical that we emphasise the importance of and seek to mitigate this trauma whenever we can. This is especially the case when the alleged victim is a child. That is what the Bail Amendment Bill 2022 seeks to achieve. Thank you, Attorney-General. This summed up the intent of this bill perfectly, and I also thank you for your incredible work in getting this bill drafted and to this place. This bill has been over a year in drafting as the government consulted and sought to get the balance right. I believe this balance has been struck and been struck well, and the result has kept the safety and care of child victims of sexual abuse paramount. These proposed reforms ensure child victims are at the centre of decisions around bail. Under this bill, new bail considerations will ensure that concerns specific to child victims of alleged sexual offences are front of mind for all of those bail decision makers. Those considerations include having regard to the conduct of the accused towards the alleged victim and their family since the time of the alleged offence. This will allow a bail decision maker to determine whether there is a pattern of behaviour, such as grooming, controlling or coercive conduct, which anyone who has any exposure to offences regarding a child's sexual abuse know are very common threads to that offence. This consideration will also be further extended to include the alleged offender's conduct towards victims and family members of victims of offences that they have been convicted of in the past. Again, to examine the accused's behaviour and assist in the development of a risk profile to inform the decision as to whether they should be released on bail. In addition to this, the Bail Amendment Bill 2022 provides for a bail decision to be deferred for up to 30 days. This will allow a bail decision maker to consider what, if any, bail conditions should be imposed to enhance the protection of a child victim of an alleged sexual offence. On this amendment, it is important to note that bail decisions can be made by both judicial officers and authorised officers, and commonly, authorised officers are police officers. Currently, when a police officer may be required to consider bail, they may not have comprehensive information before them. Information most reasonable people would consider necessary for such a decision to be made. This includes matters such as the child victim's physical and emotional well-being, or detailed information about their living arrangements. Under this Bail Amendment Bill, the bail decision maker's ability to defer consideration for up to 30 days allows them to gather and consider this information and have that information...
Member for Vic Park, could you just give me just give me 1 minute?
Yep.
Could everyone just please bear in mind the member for Vic Park's trying to make a speech here. If we could all just give her some energy and time. Thank you. Go ahead, member for Vic Park.
Thank you, Madam Acting Speaker. Under this Bail Amendment Bill, the bail decision maker's ability to defer consideration of bail for up to 30 days allows them to gather and consider this information and have that information inform their decision regarding what, if any, bail conditions should be imposed. This ability to defer consideration of bail does not limit an accused's right to be brought before a court as soon as is practicable. This Bail Amendment Bill also requires a prosecutor to inform a bail decision maker of any safety or welfare concerns expressed by the child victim in relation to the release of the accused and the reason for those concerns. Under this bill, the bail decision maker will be required to have regard to those concerns when determining bail. In other words, the concerns of child victims cannot be ignored when making a decision regarding an alleged offender's possible bail and its conditions. This express provision elevates the voices of child victims, which is not only important in terms of consideration of their safety when making bail decisions, but also asserts to these child victims that their voices matter throughout the justice process, that their voices matter now and will always matter. This can go quite some way in their path of recovery, as being the victim of a sexual offence is indisputably a trauma. In addition to the child's victim's voice, the voices of the victim's family member or a police officer investigating the offence are also counted. These voices can also inform the prosecutor that the victim has expressed a concern that their safety and welfare if the accused is not kept in custody. And the prosecutor must then inform the bail decision maker of that concern and the reasons for it. Again, the bail decision maker must have regard to that consideration and that information. Again, the voices and concerns of the child victim and those who care for them cannot be ignored. The introduction of these new bail considerations will ensure that concerns specific to child victims or of alleged sexual offences are front of mind for bail decision makers. The new Clause 3AA of the Bail Amendment Act 2022 also ensures that when a bail decision maker is making bail decisions for alleged offenders of a sexual offence against a child victim, that decision maker must have regard to the age of the child victim, the age of the accused, whether the child victim is in a family relationship with the accused, which is all too common, the importance of safety, continuity, security and stability in the child victim's living arrangements and family and community relationships, and the physical and emotional well-being of the child victim. The Bail Amendment Bill 2022 also requires a court to consider the fact that a person has been convicted of an offence, together with any sentence that is likely to be imposed, when determining bail for an accused when awaiting sentencing. Very importantly to my mind, this bill also expands the list of serious offences under the Bail Act 1982 to include sexual offences against children and several other offences in the Western Australian and Commonwealth statute books. The bill will delete the definition of serious offence currently in the Bail Act. Currently, a serious offence is defined as an indictable offence that attracts a penalty of imprisonment of 5 years or more. However, there are some child sexual offences that can attract penalties of less than 5 years imprisonment, such as indecent dealing with a child over 13 and under 16 years of age. Let me say that again, as I'm sure there are members in this place, and definitely members of our community, who would be surprised and disturbed to know that there are some child sexual offences, such as indecent dealing with a child over 13 and under 16 years of age, that are not currently considered a serious offence. I believe such offences are very much serious, and the amendments of this bill before us reflects this fact. This bill does indeed get the balance right between the rights of alleged child victims and alleged sexual offenders. Both of these parties have rights. This bill keeps child safety paramount, but does not diminish the rights of the alleged offender. It does not erode the presumption of innocence. As the member for Cockburn has stated, the very notion and existence of bail reflects this presumption. What this bill does do is elevate the voices of alleged victims. It gives them a voice in this critical step of the justice process, which they didn't have before and should not be denied. I also cannot emphasise enough the traumatic effect of sexual offences on child victims. They are lifelong, and at the beginning of this lifelong journey of recovery is the justice process. In this place, in the consideration of this bill, we must recognise the traumatic effect that the release on bail of alleged abusers can have on their victims. As the Attorney-General has said, it is critical that we emphasise the importance of and seek to mitigate that trauma wherever we can. These reforms seek to go as far as possible to ensure the vulnerability of child complainants of sexual abuse remain front and centre at each step of the bail decision-making process, without undermining the precepts of our justice system. the value of elevating the voice of child victims to ensure their voices and the voices of their family and the voices of those investigating these alleged crimes are heard cannot be underestimated. As I've mentioned, the reforms within this bill can go some ways towards the healing process for child victims, because as we elevate a child victim's voice, we also help elevate them from being a child victim to a child victim survivor. I believe this Bail Amendment Bill 2022 will go some way towards ensuring child victims or child victim survivors are our priority and remain so. Madam Acting Speaker, I wholeheartedly congratulate the Attorney-General on the development and presentation of this meaningful legislation and commend the Bail Amendment Bill 2022 to the House.
The question is